Oh, I just want to check, we did have Zachariah here?
Yes.
Okay. Well, in this matter, as the parties know, we had quite lengthy amount of hearings in this particular case. We had obviously multiple days that stretched out, unfortunately, over a considerable period of time. And in hindsight, when I look back on that, it's very unfortunate. This matter should have been resolved sometime in last fall, before we had all of this this delay. The court notes that we originally started the trial back on December 2nd, 2025, and had multiple days after that. Culminating just last week with a final date of March 3rd, 2026, leading up to today's date. Parties were divorced by a judgment of divorce entered back on December 7, 2020, and the judgment of divorce provides the parties with shared joint legal and physical custody of the children, and the parenting time was to be as mutually agreed, and at the time, the children lived with the with the defendant in Missouri and attended school there. The the plaintiff then initially had parenting time during the summer in Michigan, as well as Christmas break, Thanksgiving, and spring breaks. The parties operated under the judgment of divorce until approximately February 2023, and pursuant to both of the parties' testimony, the defendant was going through an abusive relationship, and it was considered that it was not good by both of the parties, not good for the boys to be in the defendant's home. So the parties agreed that the boys would live with plaintiff in Michigan until the defendant was out of the relationship and had a stable home. Caleb and Zachariah moved to Michigan with the plaintiff in approximately February 2023, and they remained there until August 2025, or in essence, about 2.5 years. After moving to Michigan in February 2023, the parties essentially reversed their parenting time schedule in the judgment, and the defendant was having the boys in the summer, Thanksgiving, holiday, Christmas, and spring break. On August 13, 2025, the plaintiff filed an ex parte motion regarding custody and parenting time. As a result of the motion requesting the return of the boys, the court entered an ex parte order on August 14, 2025, ordering the defendant to return the children on August 17, 2025. The testimony would show that the defendant did not return the children on August 17, 2025, but they met on August 19, 2025 to return the boys. The reason being, she says she did not receive the order for the return of the boys until after the 17th. Caleb and Zachariah were brought to the exchange location in Battle Creek. Caleb was turned over to the plaintiff, but Zachariah would not get out of the defendant's car. The defendant left with it. There were voluminous pleadings filed leading up to these particular hearings. Court will note first there was an ex parte motion regarding custody and parenting time filed on August 13, 2025. There was also a show cause order issued on August 19, 2025. Defendant's mother's motion to determine schools, motion for counseling, motion for evaluation for learning disability and developmental disorders filed likewise on August 19, 2025. And defendant's verified ex parte motion for order returning children, or requiring plaintiff to show cause for violation of a court order the same date, August 19, 2025. On August 26, 2025, defendant filed objections and a verified motion to set aside the ex parte order regarding custody and parenting time entered on August 13, 2025. Plaintiff filed a response to defendant's objection and verified motion to set aside ex parte order regarding custody and parenting time filed on September 17, 2025, and defendant's mother's response to motion to show cause was filed on September 18, 2025. Those were the issues, the pleadings that were addressed in the evidentiary hearings that we had in this particular matter.
Buckle up, guys. Today we are stepping into a case that already feels heavy before it even begins. The judge opens calmly, but the tone is unmistakable. This has been a long, drawn-out battle. Just in these opening seconds, you can sense frustration beneath the surface, like something that should have been settled long ago spiraled out of control. It's not loud or dramatic yet, but that quiet acknowledgement of time wasted sets the stage. You instantly know this is a simple custody case. This is something that dragged on, and that always means complications ahead.
After the court held a motion hearing in response to the defendant's objections and their motion, filed a motion hearing on, or heard a motion hearing on September 22nd, 2025. And at that hearing, the court ordered that the ex parte order would remain in full force and effect. And a order was entered after hearing on that motion. That order was dated 10/8/2025, and the order stated the court would not set aside the ex parte order, would schedule the motions for evidentiary hearing. The court then, as I stated, there were evidentiary hearings, the first being on December 2nd, 2025, January 27, 2026, February 24, 2026, and then on March 3rd, 2026. The court has heard extensive testimony concerning the issues before the court. Court, I will tell you as I go through this, the court is not able to comment on all of the testimony or evidence that was presented, as it took multiple days, and the court, unfortunately, if I had to comment on everything, it would take multiple days to do so. And so the court is going to hit the highlights relating to the court's finding. Court has considered all of the testimony, the various exhibits, and considered all the witnesses, and also has considered the credibility of each of the witnesses. Credibility is always a consideration in every case. Oftentimes, a party will allege that the other party or their witnesses were not truthful or were lying. The court has always, however, found that inconsistencies in testimonies does not mean that an individual has lied. Conflicting testimony can occur as a result of a witness's background, perception, bias, understanding, misunderstanding, mistake, and unfortunately sometimes just self-serving testimony. The court would note that the court believed considerable self-serving testimony in this particular case. When inconsistencies occur, the court will attempt to determine if they can be reconciled with other testimony or evidence. And again, in making the finding, the court does note that I have weighed the inconsistencies and the testimony in coming to the ruling in this particular matter. The parties had brought up a number of statutes in this case, which the court has also considered. First, MCL 722.23, which is the best interest of the child test, and the factors delineated under the statute. We'll address those today as well. Next, the court has considered MCL 722.27A regarding parenting time, and this statute incorporates MCL 722.23 in that the court shall, or parenting time shall be granted in accordance with the best interest of the child, and it is presumed to be in the best interest of the child or children to have a strong relationship with both his or her parents. The statute further provides that a child has a right of parenting time with a parent unless it is shown on the record by clear and convincing evidence that it would endanger the child's physical, mental, or emotional health. The court has considered the various factors to determine what parenting time is in the best interest of the child. We'll go over those later as well. The first task in any case involving looking at custody of the children is to determine if an established custodial environment exists between the children and a parent. An established custodial environment exists if over an appreciable time the child naturally looks to the custodian in that environment for guidance, discipline, necessity to life, and parental comfort. The statute provides that the court can consider the age of the child, the physical environment, and the inclination of the custodian the child has to the permanency of the relationship.
All right, guys, now the judge starts laying out the history, and this is where the foundation of the entire conflict takes shape. We hear about the divorce, the shared custody agreement, and how things initially seem balanced. But then comes a turning point. An unstable situation forces the children to move in with the father. What stands out is that both sides agreed at the time, which makes everything that follows far more complicated. This wasn't a forced decision. It was mutual. And when mutual agreements later turn into disputes, that's where things usually get messy and deeply contested.
The court will note that the statute in this matter does state that it's who the child naturally looks to, so the court considers that from the standpoint of the child and not from the parent. From entry of the judgment on December 7, 2020, until approximately February 2023, the children remained with the defendant, excepting for the summer, spring break, Thanksgiving, and Christmas breaks. There's no dispute that during this particular period of time, the defendant experienced an upheaval in her life in early 2023, and that prior to that time, the defendant maintained an established custodial environment with the children. However, this changed when she relinquished care of the children in February 2023. The defendant testified that plaintiff, his care of the children was to be only temporary until she got her life back in order and she had stable housing. She claims that she wanted the children back after school year in June of 2023, and she claims that she asked for the return of the children after this time as well. However, the court would note in reviewing the file in this matter, the defendant did not take any action. She did not file any motions to reacquire the children until this dispute arose in August 2023. Plaintiff maintained the sole care of the children for 2.5 years until defendant resorted to self-help for not returning them to the plaintiff. In discerning the established custodial environment, the court must use the facts that exist at the time of the hearing, regardless of how they came about, and that is the Trudel case at 197, Mishap 690, a 1992 case. A change in the parenting time schedule that will have a significant impact upon the time that the children spend with the parent may amount to a modification of the child's or children's established custodial environment. The Lieberman versus Orr case at 319, Mishap 68. Although the court has previously held that repeated changes in the parental custody and uncertainty because of an upcoming trial precluded the establishment of a custodial environment. The Bowers v. Bowers case at 198, Mishap 320. The appellate courts have held that a temporary custody order of 15 months did not establish a custodial environment. That's the Mazur versus Mazur case at 184, Mishap 111, 1990 case. The court had previously also held that 2 temporary orders over a 6-month period was not an appreciable period of time to create an established custodial environment. Meyer v. Meyer, 153, Mishap 419. And In re Brays at 149, Mishap 103, the court held that custody that lasted 9 months did not give rise to an established custodial environment. During the 2.5 years in plaintiff's care, he provided all the routine care for the children. This is not disputed. The defendant lived out of state, communicated with the children, exercised her parenting time, but she was not involved in the daily basis for the children. The plaintiff enrolled the children in the Brick Elementary when he received them, where they continued until these proceedings commenced. Plaintiff provided the daily care for the children. Plaintiff testified about his good relationship with the children, how he provided with them with guidance and other essential needs. The court will address this more in depth when we examine the best interest factors, but it does appear clear from all of the testimony in this matter that the children, being solely in his care, that he maintained the established custodial environment throughout the 2.5 years and when this matter arose. The appellate court found in Hall v. Hall at 156, Mishap 286, where the mother relinquished custody and the father provided a stable environment for 17 months, that mother no longer had an established custodial environment with the children. The plaintiff testified that, again, he worked with the children during this time on, talked about manners, how to proceed, how to process their emotions, how to respect their elders, and other things that would provide guidance to the children. So with that, as I said, the court does believe that the established custodial environment was with the plaintiff father in this matter. That is important because pursuant to the statute in these cases, that when there is an established custodial environment, the court cannot change that established custodial environment without being presented with clear and convincing evidence. Clear and convincing evidence is evidence which is so clear, so precise, and so compelling that it leads the court to come to a solution without hesitancy, and so the court will look at it from that particular standpoint. The court will next go through the factors. The first factor that the court has to, under the best interest of the child test, is the love, affection, other emotional ties existing between the parties involved and the child, or children in this case. It does appear from the testimony that both of the parties love their children and the children love them. Aaron Zimmerman, the stepfather, stated he believed that the boys were bonded with the defendant, that they love her, they play with her. He did say one minute they'd say something, the next minute they'd say they want to be in Michigan. John Zimmerman, the step-grandfather, testified that Caleb and Zechariah were normal kids. The defendant was bonded with them. They exchanged hugs. They were loving exchanges. And he said they had not seen any emotional behavior in Zechariah other than normal 8-year-old behavior. Victoria Lambus, the defendant's co-worker, testified that the defendant loves the children, they love her, they would exchange love, hugs, they would tell each other that they loved each other, etc. Miguel Galindez, the plaintiff's father, testified that plaintiff interactions with the children were phenomenal, that the children react to plaintiff as a parent. They engage with each other, they laugh, they joke, they never express fear of the plaintiff, and both parties testified about the love and affection they gave and received from the children. Also, the plaintiff testified that the children loved both of them. As a result, the court will find that this factor weighs equal as to both parties.
Now, this is where things take a sharp and emotional turn. The legal system steps in with an emergency order demanding the children be returned. But what follows is pure tension. The exchange happens, but not completely. One child gets out of the car, and the other refuses. That moment is powerful because it's not just legal anymore. It's personal, emotional, and unpredictable. When the defendant drives away with the child, it instantly escalates everything. This isn't just disagreement now. It's defiance, and moments like this often reshape how a judge views the entire situation.
Next factor is the capacity and disposition of the parties involved to give the children love, affection, guidance, and continuation in the education and raising the children in his or her religion or creed, if any. Again, Aaron Zimmerman, the stepfather, stated that exchange of August of 2025, that Caleb jumped out of the car and Zechariah wouldn't get out. He said that the defendant tried to talk to Zechariah about getting out of the car, and Miguel Galindez, the grandfather, testified about the defendant's discipline and said that when he was around, when the parents even either lived with him, that she would frequently yell at the children and had those types of a relationship. Court looks at, again, the two factors: the capacity. Court believes both parties have the capacity. The disposition is, do they carry through with what they claim that they attempt to teach the children with, and how they attempt to raise them. The court would note that, again, at the time that this action arose, that the children were enrolled in Brick Elementary, that they were continuing, and that they continued through the Brick Elementary educational curriculum. And so the court will find that, again, at least with regard to the continuation of education, that the plaintiff was responsible for that and carrying that through. But as I weigh this, the court does believe that this factor does weigh equally as to both parties. Next factor is the capacity and disposition of the parties involved to provide the child with food, clothing, medical care, and other remedial care recognized under the law in place of medical care and other material needs. Clearly, when the court will note that Victoria Lambus testified that the children are cared for when they're with the defendant. Defendant claims that plaintiff provided basically for their doctor and dental visits, but that he did not notify her until after the fact. Court will note that both parties provided for the children when the children were in their respective care. The defendant repeatedly alleged that plaintiff was not cooperative with assessing the children for counseling, but the court will note that she had the children each and every summer, She had joint legal custody, and she didn't do anything either during the entire time that the children were in the care of the plaintiff until August of 2026 in this case. For the 2.5 years before August 2025, the plaintiff provided for the material needs of the children, but the court will note that the defendant did provide for the children when they were in her care for the summer, so the court will find that that factor is equal as to both parties. Next factor is the length of time the children have lived in a stable, satisfactory environment, and the desirability of maintaining continuity. The parties both testified about the environment that they have. From the testimony, as well as from the testimony of witnesses, it does not appear that either of the home is unstable or not a satisfactory environment for the children, and that, in fact, they have, again, been raised, and again, there's no testimony about any impending changes in the home, so the children will get into that a little bit later, but it does appear that both of the homes are stable, satisfactory environments. The court will find this factor is equal as to both parties. Next, the permanency of the family unit, the existing or proposed custodial home or homes. The plaintiff testified that he'd had 2 girlfriends since since February of 2023, and his current relationship with Alice does appear to be permanency as to that. The defendant has remarried and therefore has a permanent relationship, and it does not appear that there are any proposed changes or things of that nature, so the court will find this factor to be equal as well. Next factor is the moral fitness of the parties. There's not been a substantial amount of testimony as it relates to moral fitness, but the typical things that we would look at as far as any addictive behavior, any criminal behavior, things of that nature, the court will look at and find that, again, there hasn't been any substantial difference between the parties in this particular case, so the court will find that this factor is equal as to both parties. Next is the mental and physical health of the parties involved. The testimony has been that the parties are in good mental health and don't have any physical disabilities. The only testimony from the plaintiff was that he had some long-term memory loss, but that he was not on any medication, and that did not impact the care of the children. And he testified, I think, that he was just recently, or had a, I guess you'd say
All right, guys, what comes next is a flood of legal action, and you can feel both sides digging in hard. Motions, objections, counterfilings. It's a full-blown legal war. Each side is trying to regain control of the narrative, and the pace of filing shows just how intense this conflict has become. But the key moment here is the judge refusing to overturn the earlier order. That decision quietly reinforces one side's position while putting pressure on the other. It's not flashy, but it's powerful, because in court, these procedural wins often shape the final outcome more than emotional arguments do.
Appointment with the VA and had been examined in regard to that, and that there were no issues. The court will find that this factor does not favor either party. Next is the homeschooling community record. Court took the testimony of Jennifer Perot, the principal at Wolf Branch. She testified that her school was in the top 10% in her state, that Zachariah was doing well. There were no red flags academically, no behavior issues. Sonia Pina, the second grade teacher at Wolf Branch, said that Zachariah was a hard worker. He was helpful, respectful, mostly happy, and he was passing, meeting expectations, and that he did not qualify for additional help. And I would say that's contrary to the defendant's testimony about needing so much additional help. And I would say, in any event, with the testimony that occurred from the teacher, clearly any issues that happened did not start in September of 2025. Mr. Zimmerman testified that the boys had workbooks that they used over the summer, and that he had to fight with the boys every day. That it would sometimes take 3 hours to get through 2 pages. He said approximately 16 questions. Defendant acknowledged that Caleb had improved over the 1.5 years during the last school year, and Miguel Galindez, his grandfather, testified about the good relationship and he provided driving and child care when the plaintiff was not available. The defendant claims that the children's attendance were problems while in the plaintiff's care. However, Michelle Cox, the teacher, testified that if attendance was an issue, that the boys would not have been allowed in the CAN program. And plaintiff testified that he did not receive anything from the school about attendance. And Cassandra Coker, the principal at Brick Elementary, testified that if the attendance would not be an issue unless it exceeded 10% of the time that the boys were in school. The principal also testified that Caleb was very social, athletic, had lots of friends, that Zachariah was quiet, he works hard, he appears happy, gets along well with others. The boys were at Brick Elementary since approximately February 2023, so approximately 3 years. Caleb had been involved in cross country, in football. Zachariah was in flag football and karate. Michelle Cox, as a teacher, also testified that the boys had, I might have mentioned this before, if they had attendance issues, they would not have been allowed in the CAN program. The court notes that it did appear that the boys were, as a result of the 2.5 years in the plaintiff's care, that they had settled in, that they had a homeschool and community record. In the plaintiff's home, the court will find that this factor does favor the plaintiff father. Next factor is the reasonable preference of the children. The court had opportunity to talk to the children at the commencement of this matter, and the court is taking their preference into consideration. Next factor is the willingness and ability of each of the parents to facilitate and encourage a close and continued parent-child relationship between the child and the other parent. In this case,
Buckle up, because this is where the judge pulls back the curtain on how decisions are actually made. There's a strong emphasis on credibility, and that's crucial. The judge openly acknowledges that not everything said in court can be taken at face value. Inconsistencies don't always mean lies, but they do matter. And when the judge mentions self-serving testimony, that's a subtle warning to both sides. It tells you the court is carefully filtering truth from exaggeration. This part might sound procedural, but it's actually setting the lens through which every piece of evidence will be judged.
the court would note that Mr. Zimmerman testified that defendant would make calls to the boys, and basically he wouldn't be able to reach the boys, wouldn't have return phone calls, etc. The defendant testified and said that the plaintiff did not encourage calls or return calls, but the court notes that the plaintiff has alleged the same thing. Plaintiff testified that defendant did not attempt to get Zachariah out of the car when the parties met on August 19, 2025, and plaintiff testified that he did encourage the boys to call defendant, but they didn't always do so. And he stated that when he got the boys initially back in February of 2023, that he did that because he realized there was a problem with in the defendant's home, and he wanted to protect her image in the mind of the boys. It does appear that, obviously, with regard to this factor, that there were shortcomings on behalf of both of the parties. And the court notes the biggest and outstanding one is the fact that the defendant did not comply with the court's ex parte order, or the order of October 8, 2025, reinforcing and affirming that particular order. In view of that, the court finds that this factor does slightly favor the plaintiff father. Next factor is domestic violence. The court would note that the defendant testified that she filed a PPO in Illinois, but however, she withdrew that and didn't pursue it after that. So the court's not going to give much weight to that because the court did not hear much testimony other than that about any domestic violence. Next is any other factors considered by the court to be relevant in the particular custody dispute. The court will note that Joel Mayer, the therapist for Caleb, said he sees him bi-weekly, has since October 2025. He said Caleb suffers from anxiety as a result of separation from Zachariah. He states he didn't see that Caleb was suffering from any trauma and that he was doing well emotionally and he had good emotional health. Next, I wanted to address more in depth the schooling, which I addressed a little bit. The defendant alleges that the boys were suffering educationally in the plaintiff's care. However, the court would note the boys have received extra assistance since the plaintiff enrolled them in Brick Elementary after they were placed in his care. And the court notes that any deficiency that the children were experiencing, again, could be attributable to the defendant because, again, the children have been receiving that extra assistance while the entire time that they were put in the plaintiff's care. So that didn't arise magically because he received the kids in February of 2020.
All right, guys, now we hit the core of the case, the concept of the custodial environment. This is where everything starts to lean in one direction. The judge carefully walks through the timeline, and what becomes clear is that the father had consistent, long-term care of the children. Meanwhile, the lack of legal action from the other side during that period stands out. Courts look at stability, not just intention, and here stability seems firmly established. This is an emotional conclusion. It's built on time, consistency, and responsibility, and that combination carries serious weight in custody decisions.
Again, to reiterate, Ms. Perot, the principal at Wolf Ranch, testified she's in the top 10% in the state. She had exemplary rating. The average class size was 20, and Zachariah she had not seen any behavioral issues in him, had not had any red flags academically. Ms. Pina, the second grade teacher at Wolf Ranch, testified good. She said Zachariah likes to stand in class and tap his pencil, and she said that's similar to what 20 other students do. She testified that not have any behavioral issues, no issues with emotional regulation. She has issues with emotional regulation. He was a hard worker, helpful, respectful, and mostly happy, passing and meeting everything in his expectations, and he did not qualify for additional help. Christine Green, a Title I teacher at Brick Elementary, she was familiar with both of the boys, and she did testify that Caleb was under level and that there was small group teaching because of their involvement in the CAN program. And she said that during the time that Caleb was in the school, that his RIT scores had improved. Ms. Coker, the principal at Brick Elementary, again testified about the issue of truancy and those particular issues, and that was not a problem. She said that the school had a behavioral interventionist, and he was not involved with the boys. Again, she had testified she's familiar with the boys, had seen them quite often, and that they were, for the most part, appeared to be happy and had friends, etc. She testified, interestingly, that her school is a national certified STEM school, and it is the only school in the state with that designation. She testified that Caleb made great growth in fall to winter, but he was not at the grade level. She stated that there were additional services available at middle school, but the CAN program was not available, but there was additional services. She interacted with Caleb, she said, about once every 2 weeks, and she testified on 3/3/26 that Zachariah I guess this would be the, no, this, we switched teachers, I'm sorry, the principal. This would be the principal from Wolf Branch, that she had testified that Zachariah had improved in math to grade level, but was still behind in reading. Using the defendant's rationale, the court can only say, used on that basis, that she'd be responsible for the fact that Zachariah was behind in reading. After weighing all of this factor, the court will note in weighing the factors, the court cannot and it does not look at all of these factors as a baseball box score, hit, runs, errors, etc., and add them up and then at the end say, okay, this is who wins in this particular matter. The court has a right to, and the appellate courts have repeatedly said the court can weigh factors differently, giving more weight to one factor over another, or in contravention of other particular factors. When the court weighs all of the factors, taking into account all of the evidence presented in this case, the court cannot find that there is sufficient, clear and convincing evidence to change the established custodial environment, which was with the plaintiff father when these matters proceeded. Excuse me. Court next wants to address the issue of the contempt because that was big. The plaintiff acknowledged that he didn't always tell defendant about doctor's appointment, school events, that he maybe was not as vigilant as he needed to be to get the boys back, calling the defendant, and that he attempted to encourage them, but unfortunately, with children of that age, oftentimes that doesn't appear to, again, cause them to initiate what both of the parents should be aware of and should attempt to enforce. Court notes, as listening to the testimony in this matter, it does appear that any deficiency by the plaintiff in this regard was simply a lack of diligence, and it was more inadvertent and was not intentional in this case. Court will also note that the defendant brought this matter up after the plaintiff had filed to have the return of the children, and it does appear to this court that, again, some of this motion in the claim of contempt was retaliatory in this matter, in that she had not brought it up at any point previously when she could have, and accomplished something or more compliance, if you would have, with the joint legal custody. The court will note that the deficiencies by the plaintiff in these regards could be corrected by specific guidance, so the court is going to order that each of the parents would notify the other of any upcoming doctor's appointment at least 72 hours before the appointment. If in fact there's an emergency or needs to have emergency care, that the parties would each notify the other no later than 24 hours after the appointment or treatment. The court will also set a phone schedule for phone calls in order that the children would have phone calls with the other parent on Tuesday and Thursday evenings at 7 o'clock p.m. for up to 30 minutes. It could be longer, but it depends, I guess, on the children and whether they wish to do it beyond the 30 minutes. Court notes that, again, I've stated that the court entered an ex parte order on August 13, 2025, ordering defendant to return the boys on August 17, 2025. As she was not served until after that date, they were going to meet on August 19, 2025 at the Battle Creek City Police Department. And defendant acknowledged that Caleb got out of the car and went to the plaintiff, but that Zachariah would not get out of the car. Mr. Zimmerman confirmed this as well, although the plaintiff had testified that the defendant did nothing to get Zachariah out of the car. Court would note that the parents in this case, the parties are the adults, and neither the court nor the parents should allow children, or at least a child of 8, to decide whether he's going to follow a court order. And the order was that the defendant would turn over the children, and she didn't do so. After Zachariah was not returned, the court had a hearing on defendant's motion on September 22nd, 2025, at which time the court held that the ex parte order would not be set aside and would be enforced. This ruling was reflected in the order after hearing on defendant's motion dated October 8, 2025. Since the September 22nd, 2025 hearing and the October 8, 2025 order, the defendant has had 7 months to comply with the court order to return the Zachariah. Court will find that she has intentionally failed to comply with 2 court orders to do so. The court will find her in contempt of court, and the court, as a result, could sentence her up to 90 days in jail. I'm not going to do that, but I am going to order and sentence her to 7 days in jail with the Calhoun County Sheriff's Department, and she shall remain in jail after the 7 days until such time as Zachariah is placed in the custody of the plaintiff. So in the event that she fails to comply at this particular point, so I wanted Zachariah here so the plaintiff can take the child with him on today's date. If that doesn't happen, then she will remain in jail until the child is turned over to the plaintiff.
This is the moment everything has been building toward. The judge clearly states that the established custodial environment is with the father. It's direct, firm, and incredibly significant. From this point forward, the entire case shifts because now the burden of proof becomes much higher for any change. The phrase clear and convincing evidence isn't just legal language. It's a barrier. It means that changing the situation won't be easy, and suddenly one side is at a major disadvantage. This is a turning point that quietly defines the likely outcome of the case.
The court has to next address parenting time pursuant to MCL 722.27A and those factors. Looking at the factors, the first is any special circumstances or needs of the children. The court doesn't find that the children have any special needs other than education, which apparently they were receiving through the CAN program and the schooling at Brick Elementary. Next is whether the child being less than one, that's not applicable in this case. Likelihood of abuse or neglect of a child during parenting time, the court has not found through the testimony any abuse or neglect, so the court will not consider that factor or give any weight to it. Likelihood of abuse of a parent during the exercise of parenting time, has been no testimony as to that. Next, inconvenience or burdensome impact of travel, that doesn't appear to be a problem. They have been able to do that for a number of years, and they had the ability to do so. Next is whether a parent is reasonably expected to exercise ordered parenting time. The court does believe that that will occur and that there would be the ordered parenting time, so the court is considering that. Next is whether a parent's frequently failed to exercise parenting time. There's been no testimony about that. Next is threatened or actual detention of a child. The court does note that there was detention of Zachariah in this matter, and the court's taking that into consideration. What the court is going to do is parties had operated for, again, 3 years with the defendant having the summer, in addition to Thanksgiving, Christmas break, and spring break. The court will continue that parenting time with the defendant mother. However, the court will note that the plaintiff was denied parenting time for a substantial period of time with Zachariah since August of 2025, and more importantly, he was denied the Thanksgiving and the Christmas 2025 holidays. So the court is going to order that for the next year, this 2026, that he's entitled to have the children over the Thanksgiving extended weekend and for Christmas break. However, the defendant will have a right to have the children from 5:00 p.m. on December 22nd, 2026 through 9:00 p.m. on December 24th, 2026 for her Christmas vacation, and then thereafter in 2027 the schedule would continue with the Thanksgiving, Christmas break, and spring break.
Your Honor, could you repeat those dates?
Yeah.
Times.
She will have 5:00 p.m. on December 22nd, 2026 through December 24th, 2026 at 9:00 p.m. for effectively 2 days of Christmas vacation period. Court notes the court, for child support, the court has garnered testimony from the parties. The plaintiff's income was $42.43 per hour for 40 hours. Defendant's income was $31 an hour for 40 hours, and the support shall be figure based upon that pursuant to the Michigan Child Support Formula and those particular guidelines. With that, I think that addresses all of the issues the court has to address in this particular matter. Ms. Bueno, is there anything else you believe the court has failed to address or needs to address before we conclude?
No, I think everything was covered.
Okay. Ms. Bueno, I'll ask that you prepare that order as the prevailing party.
Okay.
Ms. Gillum, is there anything you believe that the court has failed to address or needs to address before we conclude?
Well, Your Honor, there was no motion regarding child support, so if the court is going to address child support, I think we need to have additional testimony. I know that the plaintiff also has income for the Army reserves that was not testified to or included here. There's also the cost of health insurance and things like that that weren't considered. So the court is going to address child support. We would ask that there be some additional.
Okay, what I'll do is, Ms. Bueno, I ask that you would acquire the information concerning the military income, and then you would exchange that, and also anything as it relates to the medical insurance, that the premiums and who's on the policy, et cetera, you exchange that and you can take that into consideration for calculation of support.
We would also ask for you to reconsider the 7 days in jail. Judge, my client does work and don't want her to lose her job
I am,
7 days in jail?
I have considered that substantially. I looked at it long and hard, and the fact that it's been 7 months and she's failed to comply with this order, I could have given her 90 days. I didn't for various reasons, and I thought that word of the wise would be sufficient. The court will not reconsider that. She's going to get 7 days commencing the end of this, and that will proceed until the child's returned.
The child is here. Judge.
Yes. Well, if he's turned over, then she just spends the 7 days and nothing else. I'm just saying.
Okay. We would also like to note that the court did not mention at all the issues with CPS or the fact that Zachariah is indicated that he's afraid of dad and dad has put his hands on him. That hasn't been noted at all in any of these factors.
I considered all of that in figuring and looking at the factors. I considered that and took all of that into consideration. And if you can see, as the court went through the factors, the court, that didn't even come close to a preponderance of evidence to change, the established custodial environment. So it didn't raise to clear and convincing. And those factors we did, they were taken into consideration. And again, I weighed those factors as well. Anything else, Ms. Gillen?
Also, the court said something about the plaintiff missing out on the holidays with the kids last year. However, he's never had them. The defendants always had them for holidays. So I was just a little bit curious as to why he would make up holidays.
Well, because she kept Zachariah for 7 months, so he didn't get to experience any of the holidays in this matter, regardless of if it was Thanksgiving or Christmas. So I just said at this point, because he missed all the holidays he would have had Labor Day holiday, he would have had different school breaks, he would have had things of that nature. I'm basically granted him that particular time to make up with Zachariah what he didn't have.
Okay. My client would just ask before the court takes her and if she could say goodbye to her son.
If Zachariah is brought into the courtroom and that she's not leaving the courtroom, she'll go with the deputy. So I guess I'd say, Glenda, if you want to get the child, retrieve him, bring him in to speak to his mom before you leave, that's fine. It's up to you. And hopefully that goes well. Okay, anything else?
No.
Okay, anything else, Ms. Bueno?
No.
Okay, thank you. Again, I'll ask Ms. Bueno that she would prepare that order, submit get approval from the front of the court, et cetera. Okay, thank you. We'll stand in recess, and I know this is difficult, and the court agonized over this case substantially, and I want you to know that, again, it wasn't an easy decision, weighing all of those particular factors, and especially, as Ms. Gillum states, the factors that I didn't mention, I weighed those as well in coming up with the decision in this case. So, okay, we'll stand in recess.
All right, guys, now the judge methodically breaks down every factor that determines the children's best interests. What's fascinating is that nearly everything comes out equal. Both parents show love, both provide care, both offer stable environments. On the surface, it feels balanced, but that's exactly where the earlier ruling becomes decisive. When all factors are equal, the established custodial environment carries the most weight. So even though neither side clearly outperforms the other, the advantage doesn't reset. It stays where stability already exists. And that's how cases like this are often decided, not by emotion, but by consistency over time.